Yes, Mr. Maxwell-Scott, your turn.
Good afternoon, Mr. Chairman. I, together with Katie Sage, represent the Royal Borough of Kensington and Chelsea, instructed by DWF solicitors. The Grenfell Tower fire was a terrible and tragic disaster, which must never happen again. The fire was a human tragedy, but it was also a man-made tragedy. What I mean by this is that it started accidentally in a kitchen in a flat and spread with devastating speed and intensity for a building designed, constructed and refurbished by men and women. The ultimate achievement of this inquiry will hopefully be to ensure that when people design, construct and refurbish buildings in future, a disaster like this never happens again. The Council is totally committed to that aim. In December 2017, the full Council unanimously adopted a resolution affirming the Council's commitment to the Hillsborough Charter and the Council's determination to live by the letter and spirit of the Charter's commitments. In line with the report's recommendations, the Council reaffirmed its commitment to be open, transparent and fully cooperative with the public inquiry into the Grenfell Tower fire and to assist the search for the truth. That remains the Council's approach to this inquiry. We welcome the inquiry. We welcome the Prime Minister's decision to appoint 2 additional panel members to support your chairmanship. We will do all that we can to assist you and your team in your important work. As an example of this, I can tell you that on Monday, we wrote to your team in order to help them to identify specific documents of potential importance to your experts from within the large number of documents previously disclosed by the Council. I will say more about this later in this opening statement. I, members of the Council's legal team, and the Council's leader and deputy leader attended the commemoration hearings. The intensity of emotion that we experienced will ensure that we do not forget the human face of a disaster and the importance of searching for the truth and providing justice for the bereaved survivors and residents. That emotion and passion must energise and sustain this inquiry's desire to search for the truth. The search itself must be dispassionate. We welcome the fact that the inquiry will provide an opportunity for careful and objective analysis of the evidence in the search for the truth. We welcome the inquiry's wide terms of reference, in particular the inclusion of the following: the scope and adequacy of building regulations, fire regulations, and other legislation, guidance and industry practice relating to the design, construction, equipping and management of high-rise residential buildings. These wide terms of reference will allow lessons to be learned at a national level as well as at a local level. We note the comments in the final report of a Hackett review about the current regulatory system for ensuring fire safety in high-rise and complex buildings not being fit for purpose. We agree with Dame Judith that there is a need for a radical rethink of the whole system and how it works. The Hackett review highlights the likelihood that lessons need to be learned on a national level as well as on a local level. The reception of the final report and development since it was published suggest that this is a widely shared view. The Council is determined to learn the lessons that it can apply at a local level. The Royal Borough of Kensington and Chelsea is a comparatively small local authority. It covers an area of approximately 12 square kilometres. It has approximately 150,000 residents. It employs approximately 1,700 full-time employees. It is one of 32 London boroughs, one of 125 unitary councils, one of 418 principal councils in the United Kingdom. The Council welcomes the fact that the inquiry's wide terms of reference will allow lessons to be learned by other local authorities, by central government, and by those in the construction industry, hopefully as soon as possible. Mr. Chairman, I imagine that it is no coincidence that you have called on the Council to be the first core participant to speak after those representing the bereaved, survivors and residents. There can be no doubt from the coverage in both the mainstream media and social media that the Council is seen as the public face of those assumed to be responsible for the Grenfell Tower disaster. That the Council should be seen as the public face of the disaster is entirely understandable. The residents were tenants and leaseholders of the Council. The Council is, and always has been, the owner of Grenfell Tower. The residents lived in the borough. They voted in local elections for councillors to represent them in the Council. So the Council recognises that it is seen as the public face of a disaster and understands why this is so. The Council is very sorry that its residents suffered the terrible tragedy of the Grenfell Tower fire. It agrees with your statement on the first day of the commemoration hearings that it is so important that the truth be laid bare. The Council knows that what its councillors and officials did, knew, did not do, and did not know will be exposed to intense scrutiny in an inquisitorial process which has as its goal justice for the living and a lasting tribute to the dead. This is how it will be, and this is how it should be. On the first day of the commemoration hearings, Mr. Millett observed that the truth is not usually one big thing, but comprises many tiny fragments. Based on my own experiences as counsel to the inquest following the Lakenhell House fire, I would agree. Mr. Chairman, although you have only recently started hearing evidence, your investigation has been running full-time for over 9 months. You will therefore already appreciate that whilst the Council funded the refurbishment of a tower, which was completed shortly before the fire, a huge number of organisations with different specialisms were involved in a variety of ways in that project. This is a theme that I will return to. The narrative locally, nationally, and indeed internationally has tended to focus on the fact that the Grenfell Tower fire occurred in a borough which has been held by the same political party for many years, a borough with many wealthy residents and some of the highest property prices in the world. The unspoken and at times spoken assumption has been that these facts are somehow relevant to the cause of the fire. In other words, that the fire could not have happened in a different borough. One of the purposes of an Article 2 compliant investigation is to confirm or disprove rumour and speculation. This very point was made by Lord Bingham in the case of Amin in 2003. Although the context was different, Lord Bingham's observation that one clear purpose of an Article 2 investigation is to ensure that unjustified suspicion of wrongdoing is allayed holds true. So, Mr. Chairman, as the evidence unfolds over the coming months, I invite you to ask yourself this question. Was there something unique about the Royal Borough of Kensington and Chelsea which meant that this terrible fire could only have happened there? Or is this something that could have happened in any other borough which contains high-rise buildings with external cladding? Without seeking to prejudge the evidence, I venture to suggest that you will find that there was nothing unique about the Royal Borough of Kensington and Chelsea which meant that the fire was destined to take place within its boundaries rather than somewhere else. I'm now going to return to a theme I mentioned earlier, that a huge number of organisations with different specialisms were involved in a variety of ways in a refurbishment project. The refurbishment of Grenfell Tower, which was completed shortly before the fire, is at the centre of this inquiry. In other words, a great deal of this inquiry's work will involve analysing the dry, technical detail of a construction project. There may have been a time many decades ago when a building such as Grenfell Tower could be designed, constructed and refurbished entirely by employees of a local authority. If that was ever the case, those days have long gone. Whatever recommendations are made in the inquiry's report, it seems inconceivable that one of them would be to reverse the tide of the modern world to the extent that all the complex skills required to design, construct and refurbish a building such as Grenfell Tower should be brought in-house by local authorities. Even if that were considered desirable, and I suggest that it is not, it would be impossible to turn the clock back in that way. In this country, construction projects are generally subject to the construction, design and management regulations. The Grenfell Tower refurbishment project was no exception. The construction, design and management regulations, as the name suggests, regulate the many different organisations typically involved in a construction project. Where did the Council fit into that framework? The answer is that for the purposes of the regulations, the Council was not a relevant organisation. It did not enter into the contract with Ryden, the principal contractor. It was the tenant management organisation, the TMO, whose role I will return to later, that entered into that contract and became the employer in the language of the contract. While the Council was the owner, it was the TMO who were the client for the purposes of the regulations. The Council did not enter into contracts with the other organisations involved in a refurbishment project, many of whom are core participants in this inquiry. Those commercial organisations were either contractors or subcontractors of the TMO or contractors or subcontractors of Ryden. None of this is intended to suggest that the Council played no role at all. Far from it. As you are aware, my written opening statement outlines 10 principal ways in which the Council was involved with Grenfell Tower and its residents, both before and after the fire. Before outlining some of the roles that the Council did play, sir, may I encourage you to think of the Council in terms of its specific relevant functions, because that is likely to be both more accurate and more helpful than thinking of it as a single person like a private individual. The Council played a leading role in the decision to refurbish Grenfell Tower. It had received a sum of money, but for reasons which I do not need to go into, the way in which that money could be used was ring-fenced. The Council, together with the TMO, took the view that the refurbishment of Grenfell Tower was a suitable project into which to invest that money. It is, for all too obvious reasons, easy to forget that the whole point of the refurbishment project was to benefit the residents of Grenfell Tower and the local community by, amongst other things, upgrading the communal heating system, which served approximately 650 properties, including all the flats in the tower, installing new windows in the tower, and improving external thermal efficiency and weather tightness in the tower. The Council provided the funding for the refurbishment project. Under the Council's constitution at the time, the Council's most important decision-making body was its Cabinet. As explained in my written opening statement, the refurbishment project was considered by Cabinet on 3 occasions. on the 2nd of May 2012, when the project was given the green light with an estimated budget of £6 million. On the 18th of July 2013, when the budget was increased to £9.7 million. And on the 19th of June 2014, when the budget was further increased to £10.3 million. Those are not the decisions of a council determined to build on the cheap. The money was used by the TMO, who under the management agreement between it and the council had full delegated responsibility for all major works. Of course, the council did not simply wash its hands of the project after deciding that it should go ahead. The council kept an eye on what the TMO was doing. The ins and outs of how it did this will quite properly be the subject of detailed evidence and intense scrutiny in Phase 2. But for present purposes, the best single word to describe what the council did is monitor. The council monitored the TMO's performance of its obligations under the management agreement. Both councillors and officials played a role in the monitoring of the TMO's performance, but it was not deemed necessary to refer the project back to Cabinet other than on the 2 occasions already mentioned, when, on each occasion, Cabinet voted to increase the budget. Given the huge political and media interest in the refurbishment project since the fire, it may seem remarkable that it did not attract more Cabinet interest at the time. But may I suggest that there are good reasons why this is so. The project was not a politically controversial or politically high-profile issue. It did not involve cutting services or closing a much-loved community asset. At its core, it involved a proposal to spend over £10 million improving the accommodation of social housing tenants. As such, it had, if anything, the potential to unite those of different political persuasions rather than divide them. Before I leave the refurbishment project, I should mention 2 specific functions of the council that had an involvement with it. They are first planning and secondly building control. It is important to distinguish between them because they are separate functions. Planning is concerned with a range of considerations, including visual appearance. In other words, how a building looks. Planning is not concerned with fire precautions or other matters controlled under building regulations. Building control is concerned with such matters. Planning is a statutory function of local authorities that applies irrespective of the identity of the owner of the building or the applicant for planning permission. In the case of this project, an organisation called IBI Taylor Young Limited applied on behalf of the TMO for planning permission in the same way that a third-party organisation, such as a commercial property developer, would. And an official of the council, acting under delegated powers, granted planning permission. In 2014, people from the council were involved in the final choice of the colour of the cladding and the final choice between a cassette fixing system and a riveted fixing system for the cladding. This involvement came after the decision had been taken in 2012 to proceed with the refurbishment. The opinions expressed in 2014 related to how the exterior of the completed building would look. As I have already explained, this is a planning issue, and there is therefore nothing particularly surprising about people from the council getting involved in this way. Building control is another statutory function of local authorities that applies irrespective of the identity of the owner of the building or the applicant for building control approval. So it is, as you will have been learning during investigation, if you did not know it already, a highly technical function which is not political in nature. In the case of this project, Studio E Architects Limited made a full plans application in the same way that a third-party organisation, such as a commercial property developer, would, and an official of the council, acting under delegated powers, issued a completion certificate under the building regulations. All of this is normal and involved the discharge of a specific statutory function. The council recognises that the fact that such a certificate was issued will be the subject of detailed evidence and intense scrutiny in Phase 2, because, based on what is now known about the fire, it is clear that the cladding system, as installed in the refurbishment, did not satisfy the functional requirement of Schedule 1, Part B4 of the building regulations. As stated in my written opening, based on what is now known about the fire, it is likely that a number of specific failures to comply with the provisions of approved document B will also be identified by the inquiry. This raises a number of important questions. These include: what consideration was given to the fire safety of the cladding system? What consideration was given to the smoke ventilation system? What steps were taken by building control before the completion certificate was issued? The officials who worked in building control at the time will be called to give evidence to the inquiry in Phase 2. That will be the proper time for those questions to be asked and for those officials to give their answers and to explain their thought processes. However, in recognition of the importance of these issues and in the interests of transparency, the Council on Monday, sir, sent your team a detailed chronology in relation to building control issues, which is cross-referenced to specific documents previously disclosed by the Council. We welcome the inquiry's recent instruction of Beryl Menzies to provide expert evidence on building control issues. We hope and believe that the chronology and references which we have supplied will assist her to analyse the ways in which officials within building control considered fire safety issues. They should also assist your other experts to address a number of the questions which they have identified as outstanding in their reports. Before leaving building control, I would add the following important point. The officials who work in building control and who grant building control approval are not and do not become designers of the projects they approve. Under a design and build contract, and the refurbishment of Grenfell Tower was a design and build contract, the contractors agree to design and are paid to do so. It is well understood in the construction industry that the fact that local authorities have a building control function does not remove the duties on those paid to design buildings. Mr. Chairman, I hope I have succeeded in outlining the various different ways in which different parts of the Council, with different statutory functions to discharge, were involved in the refurbishment project. I hope that I've also dispelled some misunderstandings about the Council's role by saying something about the involvement of the many commercial organisations involved in the project, whose involvement was understandably more hidden from view. I have already mentioned that the Council monitored the TMO's performance of its obligations under the management agreement, which included delegated responsibilities for day-to-day management issues as well as for major works. I now turn to say something about that organisation, which was involved not only in the refurbishment project, but also in the day-to-day management of Grenfell Tower. So you will of course be aware of this, but some of those following the inquiry may not be, so it is worth repeating. the TMO was at all relevant times a separate legal entity to the Council, although they worked closely together. This separation was not some legal device intended to shield the Council from its responsibilities. At the time it was established, the creation of a tenant management organisation and the delegation of functions to it was considered to be a positive and progressive move. It was set up to be independent of a council, and it was independent of a council. Its constitution expressly stated that the majority of its board members must be tenants and leaseholders, and that council-appointed board members must be in the minority. From 1991 onwards, successive governments promoted the transfer of functions to tenant management organisations as a key means of improving tenant participation in the management of their homes. In 2014, the TMO reported that in a poll of its residents in September 2013, 86% of those who voted said they wanted the Kensington and Chelsea TMO to continue managing their homes. Mr. Chairman, that brings me to the end of this opening statement. Nothing that I have said in it is intended in any way to detract from the fact that the Grenfell Tower fire was a terrible disaster which tragically resulted in great human suffering and loss. We offer our profound sympathies to each and every bereaved person, survivor and resident. So I hope that this opening has helped you and others to understand some of the ways in which the Council was involved in the management of Grenfell Tower and of the refurbishment project, and of how its involvement fits in with the involvement of others. As I said earlier, the Council welcomes this inquiry and will do all that it can to assist you and your team in your important work. We hope that this inquiry can provide justice for the living, a lasting tribute to the dead, and ensure that a disaster like this never happens again.
Thank you very much. Now, next I invite Mr. Agaros to make a statement on behalf of the TMO.
Mr. Chairman, my name is Jim Agaros and I appear for the Kensington and Chelsea Tenant Management Organisation, which I will refer to as the TMO. I appear with Alice Jarrett and we are instructed by Richard Crockford and Danny McShee from Kennedy's Law. The TMO is deeply sorry for the terrible events that occurred at Grenfell Tower on the 14th of June 2017 and extends its sincere condolences and sympathy to the bereaved, the survivors and residents. TMO acknowledges that these tragic events demand a thorough investigation of how the fire started, how it came to spread so rapidly through the tower, and how so many people came to lose their lives. There should also be a thorough investigation of the underlying causes of the fire. In Phase 1, the eyewitness accounts of residents of Grenfell Tower and the wider Lancaster West estate and the evidence of firefighters from the London Fire Brigade will be vital in piecing together and understanding what happened on that night. TMO recognises the great courage it has taken for the BSRs to come forward and provide their accounts, and the courage that will be required to give evidence to this inquiry. And if we may say, this courage was on clear display during the commemoration hearings which took place in the past 2 weeks. So TMO acknowledges the central role it played in the project to refurbish Grenfell Tower and its role in the management of fire safety issues there, both before the refurbishment and during. It accepts its involvement will and should come under great scrutiny. It has fully engaged in the inquiry process and police investigation and will continue to cooperate with the inquiry as far as possible, providing all relevant documents within its control. And so, as an example, in February, when the position statements were provided, it provided a detailed position statement in which it set out what was its involvement with the refurbishment project and what it considered its role to be within that project. But so, if I may say, however, as matters that touch more directly on TMO's involvement will be considered mainly at phase 2, this opening statement will be relatively short. By way of background, I will say a little about the nature and history of TMO and its involvement in the management and refurbishment of Grenfell Tower and the fire safety issues arising there. TMO was incorporated on the 20th of April 1995 under the Right to Manage legislation. It is a not-for-profit company limited by guarantee which was set up by RBKC to manage and maintain its housing stock. RBKC remained the landlord for all social housing tenants. TMO is a resident-led organisation with a majority of local tenants on its board. It has approximately 5,600 members who are all residents of RBKC's housing stock, and it has no shareholders. Any profits or surpluses are put back into TMO to improve its services to residents. So TMO, for want of a better description, is essentially a managing agent that operates mainly in the public sector. It dealt with a full range of matters that go with the management of largely social housing stock. These included repairs and maintenance, rent collection, and communal issues such as antisocial behaviour. As of 2016, it employed some 218 staff, and its senior management team consisted of 18 people. In fact, sir, as you know, and has been widely reported, in March 2018, RBKC took back the function of managing its social housing stock from TMO, and TMO no longer has a role in that. Can I turn to its involvement in the project itself? In 2011, TMO was informed by RBKC that funds were available for the general purposes of housing regeneration, including the regeneration of Grenfell Tower. The overall purpose of the Grenfell Tower refurbishment was to improve its functionality and amenity for residents. A key driver was to bring it into line with modern standards for energy efficiency, both through replacing the outdated communal heating system and insulating and cladding the concrete exterior. Thus, and in a little detail, the refurbishment included the replacement of the single glazed windows with double glazed windows, the fitting of new external cladding and rain screen, the remodelling of the lower 4 floors to provide 9 new residential homes, the relocation and improvement of the nursery and Dale Boxing Club, and the replacement of the communal heating and hot water system with individual units which were controllable individually by residents. So while TMO is a specialist in the management of social housing stock, it is not a specialist design or construction company and had no in-house expertise in these areas. Therefore, when it commissioned the large-scale project at Grenfell Tower in 2012, and so it fully accepts it did commission the project, it engaged specialist contractors to carry out the design and construction, and consultants to advise on both regulatory and building compliance issue, including fire safety issues. TMO's role in relation to the refurbishment project was that of client, and Mr. Maxwell Scott has mentioned the regulations, but this was the role it occupied pursuant to the legislation that governs large-scale construction projects such as this one, and these are the Construction Design and Management Regulations 2007, which are known as CDM. And so while this is an important role, and if I may say, TMO does not seek to underplay the importance of its role, the regulations envisage that clients may not be specialists in design or construction, and so therefore clients are not required to plan, manage, or carry out projects themselves. So what TMO did to discharge its duties under the regulations is a matter the inquiry will no doubt consider in anxious detail, probably more so at phase 2. And so whether it did or did not discharge its legal duties will be a matter for others to judge. So TMO monitored and managed progress of the refurbishment work against budget to ensure delivery of the programme on behalf of RBKC and the residents, and liaised with residents to facilitate the works. In the initial stages, in fact, right back in early 2012, TMO procured a specialist design team which consisted largely of organisations which had already been appointed by RBKC in relation to the nearby project to develop Kensington Academy and Leisure Centre, which was known as KALC, K-A-L-C. All had been engaged following an EU-compliant tendering process. And so we've heard something about these organisations. The specialist design team consisted of and included Studio E, Max Fordham, Curtins Consulting, and Churchman Landscape Architects. TMO appointed Artelia as its agent in August 2012, although it's right to say Artelia had been working with TMO on the project before then. Artelia had a varied role in the project. Among other things, Artelia reviewed and scored the tender responses received from the 4 bidding contractors in 2013, finally recommending in 2014 that Ryden's bid was of the highest quality and offered the best value for money. Studio E was engaged at a very early stage as architect and lead design consultant. Excuse me. It, in consultation with other construction and design professionals, identified materials to be used in the cladding. And so the cladding that was eventually used at Grenfell Tower was shown to RBKC Planning on various occasions in 2014 and before. And in fact, sir, I believe we will hear that in fact there was a mock-up installed on the tower itself, which was there for a period of time. Because the showing of the cladding to RBKC was one of the conditions attached to RBKC's final grant of planning permission. And so RBKC planners also visited a number of residential tower blocks in different London boroughs, not Kensington and Chelsea, where this type of cladding had already been installed. And so, as we understand, the evidence will be heard, in some cases as early as 2010. Studio E was provided with advice by Exover UK Limited, which is a consultant specialising in fire testing and certification in connection with the fire strategy to be adopted at Grenfell Tower. TMO appointed Ryden as principal contractor, which again is a designation under the CDM regulations, following its successful tender. This was a design and build contract, and Ryden was required to carry out the design, construction and completion of both the proposed recladding and installation of windows. Prior to and during the refurbishment project, TMO engaged the services of the fire safety consultant CS Stokes and Associates Limited, which advised on fire safety matters and completed fire risk assessments at Grenfell Tower. TMO also had bi-monthly fire safety meetings with the London Fire Brigade throughout the course of the refurbishment. The refurbishment project was overseen by a number of other specialist bodies, including RBKC Building Control, which visited and inspected the project on at least 16 occasions between its inception in August 2014 and practical completion in July 2016. And Building Control signed off the final works as being compliant. A clerk of works was also appointed at an early stage and visited the site on a regular basis, assessing the quality of the building works as they progressed. Can I deal with two discrete topics, please, sir, before I move on to a last topic? One of the topics is fire doors, and it has been widely reported and is referred to in your expert reports that fire doors installed on the flats in 2011 may not have performed to the standards suggested by their fire rating. This will plainly be a matter to be investigated, but it's right to say that TMO procured these doors from a company, Master Door, who fitted them and held them out as being compliant with prevailing fire standards. Another issue is complaints. TMO recognises that one of the issues the inquiry will have to consider is what complaints were made by residents, to whom, when, and what they were about. How TMO dealt with these complaints will be considered during this inquiry, and the TMO will continue to provide all information in relation to those complaints. We fully appreciate that it's an important issue. So as a final or penultimate topic, while the cause of the fire and the way in which it took hold is complex and multifaceted, some overriding factors have emerged from the reports of the experts commissioned by the inquiry. Components of the aluminium rain screen fueled the fire and allowed it to spread up and around the tower at a great rate. Combustible materials and the lack of cavity barriers in the new windows also seem to have played a major role. Why combustible cladding was used at Grenfell Tower is something this inquiry will have to consider with great care. And so the answer may not be simple or straightforward. But what can be said is this, that the use of this material, or this type of material, had been contemplated since the beginnings of the project, when identified by Studio E and other contractors in 2012, and was visible to and seen by a whole range of technical and professional bodies, including those with specific responsibility for building control and fire safety. In fact, investigations after the fire show how widespread the use of these materials was. Numerous high-rise residential buildings, I think Mr. Mansfield said something like 300, in both the public and the private sector, were clad in the same or similar materials used at Grenfell Tower. And as we heard, only last month the government agreed to fund the removal and replacement of cladding now identified to be dangerous by councils and housing associations across the country. and work has started to remove it from over 100 high-rise buildings in the country, across the country. So TMO supports the inquiry's thorough investigation into how these materials came to be used by contractors at Grenfell Tower and so widely throughout the housing sector, and how the current systems of building regulations and fire safety, which Dame Judith Hackett found to be not fit for purpose, were not reviewed prior to this date. Finally, sir, and importantly, TMO supports a thorough investigation into the nature and implementation of the stay put policy in relation to high-rise buildings. And crucially for phase one, on the instructions, residents were given by LFB and dispatchers as events unfolded on the night of the 14th of June 2017. And so we acknowledge that answering these questions might be vital, not just for the present inquiry, but also for the safety of countless other tenants across the UK.
Very good. Thank you very much indeed. Now, it's a little early to take a break just yet, I think. So, Mr. Hockman, you are going to address us next, I think.
Yes, sir, and I'll come round.
When you're ready.
May it please you, sir. On behalf of Arconic Architectural Products SAS, which I will call, for the purposes of this oral opening, the company, I'm very grateful for the opportunity to present these brief opening remarks. Comments as to the lack of detail in written openings clearly do not apply to us, since we filled every square inch of the 10 pages allocated to us. As you know, for the purposes of this oral opening, I have, however, been allocated just 15 minutes, and I know that a tea break awaits, and therefore I'm going to limit myself to making some 10 specific points, which I hope, sir, will be of assistance to you. I should make it clear that it's not my intention to address every point made yesterday or today with which we may respectfully disagree. My first point is, as it must be, to repeat the expression of profound regret with which I began my initial remarks to the inquiry on the 21st of March. The sadness and sorrow which everyone must have felt on hearing about the fire and its terrible consequences were accentuated by watching and listening to the commemorations with which the inquiry was presented during the last 2 weeks. And I would like to add my respectful tribute to all those who had the courage to make those presentations and to those concerned in the arrangements which made it possible for the presentations to be given. My second point concerns the supply of cladding. As everyone now knows, the company was requested to supply a quantity of cladding panels made of what is known as ACM-PE, some or all of which were to be fitted to the tower. The panels were of a kind which, among others, the company regularly manufactured and supplied. They consisted of 2 sheets of aluminium with a polyethylene core. The core itself was obviously combustible. The manufacture and supply of these panels was the only part which the company played in the events leading up to the fire. I add at this point that the company had no knowledge of and in no way authorised the images shown in the screenshots referred to yesterday and would strongly disapprove of their content. These images were, it seems, created by a customer who has been left in no doubt that we wholly deplore its conduct. My next and third point relates to what I might call the legitimacy of the supply, and it is simply to stress that the supply of such panels was in itself an entirely lawful and indeed by no means uncommon circumstance. As you've already heard from others, similar panels were regularly supplied to the market, and indeed we understand that the company was a relatively minor participant in the market within the UK. Fourth point, arrangements for use. It's important to stress that, as I'm sure will be readily appreciated, those requiring the supply of such panels are invariably involved professionally in the construction or refurbishment of buildings, and it is they who decide whether to acquire the panels and in what quantities. It is they who decide whether to use the panels for a particular project, how they are to be fabricated, and how they are to be affixed. It is they who decide whether, in combination with the other components of the building, the panels can be appropriately and safely used. And in particular, it is they who decide on the combination of materials comprising the cladding system. Next, the fifth point concerns fabrication and installation. It has to be stressed that an individual panel, as manufactured by and purchased from us, cannot simply be fitted to a building as supplied. A process of fabrication is necessary, which involves adapting the panel so as to enable it to be fitted to the building in whatever way has been specified. In addition to the process of fabrication, it's then necessary for arrangements to be made for the fixing of the panel to the building itself. Separately and in combination, these processes are undertaken not by the company, but by others, and no doubt invariably in reliance upon appropriate professional advice. Now I come, as my sixth point, to the topic of regulatory compliance. The use of materials in the construction or rehabilitation of a building is, as we've heard, subject to the building regulations, which are a form of legislation, and it's also covered by published government guidance. The legislation and the guidance are not wholly prescriptive in detail as to how regulatory compliance can be achieved, though there are a number of recognised routes to compliance. In order to assess compliance, whether by one of the recognised routes or otherwise, it would be necessary to have a detailed understanding of the overall design and structural components of the building, including, of course, the external envelope. Assessment of compliance could not be, and was not, therefore, undertaken by the manufacturer of a single component part. I'll say that again, if I may. Assessment of compliance could not be, and was not, therefore, undertaken by the manufacturer of a single component part. It was for those who were responsible for the design or construction or refurbishment of the building to satisfy themselves that an appropriate route to compliance would be achieved. In particular, one route to compliance was and is recognised to be the carrying out of what is sometimes called a fire engineering assessment, which takes into account relevant features of the building as a whole, including the various components in the cladding system. This route to compliance was recognised as recently as April of this year in a government consultation paper concerning amendments to government guidance. And this route to compliance, possibly in common with other routes, does not necessarily require that every element in the building be non-combustible or of limited combustibility. Now a few words as my 7th point about product classification. And I can be very brief on this at this stage. It follows really from everything that I've already said that the question whether panels can be used in a manner which complies with the regulatory regime does not necessarily turn upon whether they were capable of achieving any particular classification. Now, I've covered 7 of my 10 points, and I propose in my remaining 3 comments to identify some of the factors, in addition to the ACMPE, which it appears were responsible for the way in which the fire spread throughout the building and for its fatal consequences. I do so not in any way to express suggested conclusions, but rather to highlight a very few of the matters which the inquiry will undoubtedly wish to address. And of these 3 points, the first, which will be my point 8, my 8th point, concerns containment. It seems that anyone assessing the fire performance and compliance of the building would have had to take into account the so-called stay-put policy. In other words, the assumption that the building was constructed in such a way that a fire in any one unit would be contained within that unit for an appropriate period of time, such as to avoid a threat to safety in other parts of the building. It seems to us, therefore, that the inquiry will wish to examine whether the refurbishment project, if appropriately carried out by those responsible for its design and implementation, would and should have been capable of ensuring that the fire in flat 16 was so contained. My 9th point concerns insulation. The inquiry, of course, will wish to examine the contribution of the individual components in the building, including those within the cladding system. And as regards the cladding system, we have to emphasise that the insulation selected for the project appears to have been the first combustible component in the cladding system, which became subject to fire and which had a significant impact on fire spread. The company was not in any way responsible for the selection or installation of the insulation material. And then finally, as my 10th point, a word about the infill panels. A feature of the cladding system which has perhaps to date been insufficiently emphasised is the incorporation of a considerable number of white polystyrene infill panels. We have seen them on the pictures. Also highly combustible, which appear between the windows on every floor from the 4th story upwards, and which will also have made an identifiable contribution to fire spread. Once again, the company had no involvement in the manufacture, selection or use of these panels. So by way of conclusion, as others do, we fully understand the enormity of the task facing the inquiry, the enormity of your task, together with your assessors and fellow panellists when appointed, and look forward to playing our part in working towards appropriate conclusions. Thank you.
Thank you very much. Well, it's a little before 3 o'clock, and I think that is a convenient time to take a break. So we'll stop now and resume at 3:15 sharp, please. Thank you. Now, Mr. Leonard, you're going to address us next.
Good afternoon. Yes, James Leonard, instructed by Watson Burton, and this is the opening statement on behalf of C.S. Stokes Associates Limited. C.S. Stokes continues with others to express its deepest sympathies and condolences to all those affected by Grenfell Tower fire. C.S. Stokes is the company through which Carl Stokes has traded in the business of fire safety since 2009, having undertaken independent fire risk assessments himself, pursuant to the Regulatory Reform Fire Safety Order, which I'll refer to as the Fire Safety Order throughout, since 2007. Carl Stokes had 23 years' service as a fire officer, and in 2007 was awarded the Fire Risk Assessment Certificate, having demonstrated proficiency for the work. In broad terms, Carl Stokes' association with Grenfell Tower began in 2009 with his first fire risk assessment as a subcontractor, and repeated the exercise as C.S. Stokes on the 20th November 2012, the 17th of October 2014, the 20th of April 2016, and the 20th of June 2016. C.S. Stokes Associates Limited is the identified core participant in these proceedings. All fire risk assessments, together with their significant findings and action plans, were provided for and to the Kensington and Chelsea TMO. The particular nature of and purpose behind fire risk assessments will, sir, I'm sure, be the subject of evidence. But in short, they represent a fire risk assessment of the building captured on the day or days the fire risk assessment is completed. The fire risk assessment is always available for the London Fire Brigade to audit as the enforcing authority, and for the TMO in this case to distribute as they see fit. The Fire Safety Order requires the significant findings of the fire risk assessment to be recorded. The significant findings are given actions for, in this case, the TMO to address. In addition, between 2010 and 2017, C.S. Stokes carried out fire risk assessments for the TMO across their portfolio of properties and was, on occasion, asked to carry out specific tasks or consider specific issues as and when requested, which included matters relating to Grenfell Tower before, during, and after the refurbishment work. Again, sir, that will be a matter of evidence in due course. C.S. Stokes is committed to assisting this inquiry as best it can, and particularly in relation to the Fire Safety Order and fire risk assessments carried out under that order, not only in relation to how matters were and remain, but how they might be improved for the future. The BSR CPs, core participants, and inquiry experts have raised a number of entirely legitimate issues about which evidence will be given. With this in mind, however, there are three specific matters I would like to address, primarily to inform, I hope helpfully, your work, sir, going forward. But these are not intended to provide answers to all the questions raised, but as I say, to assist you, particularly in relation to fire safety matters and fire risk assessments. Firstly, stay put. Stay put is a well-recognised strategy applied to purpose-built blocks of flats for many years, and it applied to Grenfell Tower long before C.S. Stokes became involved in the building. Stay put is, though, identified in C.S. Stokes' fire risk assessments as the strategy in place for the building. Stay put relies on designed and maintained internal compartmentation of the building to contain fire spread for a period of time sufficient either for the fire to burn out or for it to be dealt with by the fire service without the need for general evacuation. At the same time, it is designed to maintain the integrity of other fire protection measures, including fire escape stairs and the like. Although stay put can and is referred to as an evacuation strategy or plan, and although it is not a plan that requires immediate evacuation or even relies on a predetermined phased evacuation of a building, it should not be thought of as a policy for occupants if a fire has broken out to stay put in all or any circumstances. The Local Government Association guidance published in 2011/12, before the coroner completed the Lakanal House inquest, to which I was also a party, identified stay put policy as involving, in broad terms, the following approach. 1. When a fire occurs in a flat, the occupants alert others in the flat, make their way out of the building, and summon the fire and rescue service. 2. If a fire starts in the common parts, anyone in those areas makes their way out of the building and summons the fire and rescue service. 3. All other residents not directly affected by the fire would be expected to stay put and remain in their flat unless directed to leave by the fire and rescue service. The LGA guidance, the Local Government Association guidance, survived unamended by the Lakanal recommendation letters, goes on at paragraph 19.2. It is not implied that those not directly involved who wish to leave the building should be prevented from doing so, nor does this preclude those evacuating a flat that is on fire from alerting neighbours so they can also escape if they feel threatened. Sir C.S. Stokes does not underestimate the multitude of factors that were presented to the London Fire Brigade by the fire at Grenfell Tower on the 14th of June 2017. It was a fire that spread with unforeseen intensity and speed as a result of fire igniting cladding material on the external walls. Without wishing to prejudge the evidence, the inquiry will have to consider whether or not the fire developed in a way that appears wholly inconsistent with a fire in a building that was said to have complied with the functional requirements of building regulations and approved document B. If that is right, the fire protection measures in place at the time, on the basis that it did so comply, were subjected to a fire they had never been designed to address. Whether, and if so, the stay-put policy needs to progress from stay-put advice to directing residents to leave from the building is an operational firefighting decision in the event of a fire occurring. As to planning in advance, the Department of Communities and Local Government Fire and Rescue Authority's Operational Guidance Generic Risk Assessment 3.2, which did come about after Lakanal, and those familiar with what happened in that case will recognise features of it within the changed narrative, in February of 2014, addresses directly the issue of a contingency plan, referred to already in your proceedings, sir, as a Plan B. Addresses the issue of a contingency plan on the part of a fire and rescue authority. Under GRA 3.2, by way of summary only, the relevant fire and rescue authority is required to have contingency plans which should cover, and I quote, an operational evacuation plan being required in the event the stay-put policy becomes untenable. It goes on. Advice offered to callers to remain in their property during fire survival calls, and I quote, must be re-evaluated throughout the incident. Callers may need to be advised to leave their property or guided from it by firefighters. This inquiry will have to consider whether any London Fire Brigade contingency plan for managing evacuation from Grenfell Tower would ever have contemplated the need for a full or even staged evacuation so quickly. From a fire risk assessment perspective, had such a need been identified, stay put as a strategy would never have been appropriate in the first place. That, sir, will be a matter of evidence for you to consider as we progress. The second point I want to raise, if I may, is this. Are the external walls of a building, such as Grenfell Tower, covered by the fire safety order? So this is a matter that inquiry may feel it has to address in due course, and there may be some urgency to it, and I'll explain why. In written submissions seen in advance, at least one of the BSR core participants suggests that the external walls are within the scope of the fire safety order. As you know, sir, the fire safety order is one of the key pieces of legislation in this area. All of CS Stokes' fire risk assessments on Grenfell Tower were carried out pursuant to the fire safety order. The fire safety order applies not to domestic premises occupied as private dwellings, i.e. the flats themselves within Grenfell Tower, but to those parts, and I quote, used in common by the occupants of more than one such dwelling. If the external walls were to be regarded as within the ambit of the fire safety order, therefore, they would have to be regarded as parts of the building that were, and I quote again, used in common by the occupants. So your expert, Colin Todd, has said that in his view, although ultimately it may well be a matter for you, of course, a construction of the fire safety order allowing for that conclusion would be perverse. Setting aside the practical implications of the external walls being included as a common part, one struggles to find any guidance document, and there are many, that comes close to suggesting it did. And moreover, as I perceive it, the Dame Judith Hackett report appears to proceed on the basis, almost taken as read, that external walls are not included within the fire safety order. It was an issue focused on in the post-inquest recommendation letters that followed the Lakanal House fire of 2009. By letter dated the 28th of March of 2013, Her Majesty's Assistant Deputy Coroner specifically invited the government to consider providing more guidance on what was meant by common parts, and nothing has changed. CS Stokes' position is that the external walls of the tower do not form part of the common parts of the building for the purposes of the fire safety order. Further submissions as to the reasoning behind that would follow, sir, at your invitation. Conversely, Section 1.5 of the Housing Act of 2004 does specifically include external walls. The extent of the duty in that regard may also be a matter, sir, for you to address in due course. However, even if the fire safety order should be construed so as to include the external walls, Colin Todd's further opinion is that it has never been custom and practice for fire risk assessments, including those carried out by fire safety specialists, to consider external wall construction. If a contrary view on construction is to be taken, so that may need to be taken with some urgency because of its impact on the fire safety community at large. Even though we take the view that the fire safety order, irrespective, as it were, of the strictly legal position taken with regards to the fire safety order, the Local Government Association's guidance, already referred to at paragraph 72, invites, and I quote, particular attention to any rain screen or other external cladding that has been applied and to facades that have been replaced. That is not a paragraph that directly addresses fire risks assessments. At the time of the CS Stokes fire risk assessment on the 17th of October 2014, the refurbishment was underway, save, though, for a single piece seemingly in place as a visual example, there was no external cladding in place at that time of inspection. Following the fire risk assessment, in accordance with the fire safety order, the record of significant findings and action plan, also dated the 17th of October 2014, was produced by CS Stokes. In addition to the proposed cladding being noted in the first row of significant findings, the last significant findings item identified the following as a risk with a high priority for resolution, and I quote, "The external face of this building is to be overclad. The piece of cladding fixed to the external wall at the moment is on timber battens." In response to this risk, CS Stokes recommended actions to be taken, which can be paraphrased as follows. 1. The contractor to provide the scope of the works for the cladding, how it was to be fixed to the building. 2. The contractor to provide information about the fixings to be used. 3. The contractor to provide the fire rating of the cladding and the fixings. 4. The contractor to provide building control officers' acceptance of the fixing system and cladding used. Even though, therefore, outside the scope of the fire safety order, by identifying the proposed overcladding as a risk or hazard and in accordance with the Local Government Association guidance, CS Stokes invited particular attention to the proposed cladding system and thus promoted active consideration of the safety of the cladding system and fire safety issues. Sir, a cladding system designed by specialists in the construction industry and approved by building control should not have spread fire in the way that it did at Grenfell Tower on the 14th of June 2017. Neither should it have compromised internal compartmentation and the stay put policy in the way that it did and at the speed it did. Thirdly and finally, what was meant by fire-rated cladding, and I quote, in the April and June 2016 fire risk assessments. In its 26th of April 2016 fire risk assessment, CS Stokes commented, as a result of information received, as follows. New external cladding has been fitted to this building as part of the project of refurbishment and reconstruction, work being undertaken on and within the building. The original external face of this building has been overclad. The new fire-rated cladding is fixed to the outface of the building by metal fixings, and the whole process has been overseen by RBKC, Building Control Department and officers. They have approved and accepted the fixing system and cladding used. In its 20th of June 2016 fire risk assessment, CS Stokes repeated that comment in identical terms, and the building control completion certificate for Grenfell Tower refurbishment was issued, so as you know, on the 16th of July 2016, as CS Stokes was informed it would be. The comment that the cladding was, quotes, fire rated was derived from CS Stokes having been assured that building control had overseen the whole process, had approved the fixing system and cladding used, had signed it off, and that it complied with building regulations in relation to external walls and the relevant sections of approved document B. Compliance with the relevant sections of approved document B represented, on CS Stokes' understanding, a fire rating in accordance with approved document B, paragraphs 12.5 to 12.9, or at least a functional equivalent by reference to full-scale British Standard test data. Irrespective, however, of that detail in approved document B's detailed fire rating, paragraph 1 of paragraph 12.5 of approved document B reads as follows. The external envelope of a building should not provide a medium of fire spread if it is likely to be a risk to health and safety. The use of combustible materials in the cladding system and extensive cavities may present such a risk in tall buildings. It'll be a matter for you to determine, sir, but even if there is a gap or an apparent gap in the fire safety order relevant to the external walls, the functional requirement of the building regulations steps in. You will know, and others who've looked at it will know as well, that compartmentation, crucial to this issue, is worthy of an entire section in approved document B under B3, which stresses the importance of compartmentation in the context of resisting fire spread. It will be a matter for this inquiry to determine and consider that any external wall that compromises compartmentation and stay put is arguably bound to represent a risk to health and safety. If a cladding system was passed as compliant, the converse should be capable of being taken as true, namely the system with approval did not present a risk to health and safety. The same can be said of the letter of the 6th of April 2017 from the London Fire Brigade that's already been referred to. That letter, in fact, focuses significantly on compliance with the Building Regulations Part B and all parts of approved document B as a way of ensuring ongoing public safety. Sir, you, sir, by way of conclusion, will be very interested, no doubt, in due course, to ascertain precisely what did happen as part of the building control process, as are many others. But until that has occurred, sir, we remain committed to assisting you in any way we can. But that is all I propose to say on CS Stokes' behalf.
Thank you very much indeed. Now, the next person to address us is Mr. Gibson. Thank you. Gibson.
Sir, I appear on behalf of Celotex Limited, instructed by Linklaters. Sir, it is of the utmost importance to our client and all the representatives of the company that I express our deep sympathy both to the families of those who lost their lives as a result of the fire at Grenfell Tower, and to everyone who has been and remains affected by the devastating and tragic events of that night. The very moving and distressing commemorations which we have seen and heard over recent days bear witness to the terrible pain being suffered by so many. And we fully understand the demand and the need for answers which have been expressed so powerfully and with such dignity. We have also carefully noted the words of counsel to the inquiry in his opening statement, emphasising that core participants will rightly be expected to provide clear evidence and engage rigorously with the issues that directly concern them. That, we recognise, is essential in order to assist this vitally important inquiry in achieving its objectives, which include making recommendations designed to ensure that such a fire never happens again and that there are major improvements in safety in the areas under investigation. Sir, we have sought to comply with the inquiry's directions to date in that spirit. As the inquiry knows, Celotex manufactures and distributes insulation products, some of which were used in the refurbishment of Grenfell Tower. In our position paper, we carefully sought to set out and explain Celotek's role and involvement as requested, in particular in relation to the testing, marketing and supply of its insulation products, and we identified key documents. That position paper has been shared with other core participants, so I do not seek to lengthen this opening statement by repeating its contents along with the contents of our written opening. But in conclusion, I would like to underline, particularly having regard to all that has been said and that I've heard today, Celotek's continued commitment to full, objective and transparent engagement with this inquiry. Thank you.
Thank you very much. Now, Mr. Beer, you're going to make a statement on behalf of the Ministry next.
So that's right, I appear on behalf of MHCLG. The loving and moving commemorations that rightly form the start, if not the centrepiece, of this inquiry provide a reminder, if one was needed, that although the inquiry may at times become enmeshed with technical and scientific evidence, at its very heart, this tragedy concerned people and the loss of human life. For our part, and by that I mean the people, the individuals who make up the department that I represent, there is a collective desire that human tragedy is the compass which gives us our bearings in this inquiry, as we seek to ensure that the lessons of the tragedy are learned. The department was present at each and every one of the days of the commemoration, ensuring that what was said was heard, and will continue to be present throughout the inquiry's hearings. You'll know, sir, that the department is primarily concerned with phase 2 of your inquiry and not phase 1. But notwithstanding that, and the fact that the department will have the opportunity to make a full opening statement at the commencement of phase 2 of the inquiry, the department does wish to make a short opening statement at the beginning of this phase. And it does so firstly in recognition of the importance of phase 1 of the inquiry. And that's because it is only by examining the phase 1 issues that the inquiry has any hope of making robust findings in relation to the phase 2 issues. But secondly, we wish to make the statement to emphasise that although we are not actively engaged in phase 1 of the inquiry, the department is nonetheless carefully monitoring and responding to the evidence prepared for and given in phase 1 of the inquiry, insofar as that evidence relates to matters that remain within the department's areas of responsibility. As I've said, in relation to the phase 1 issues identified by your council, which fundamentally encompass factual issues directly relating to the events of the 14th of June, the department has no direct involvement or direct knowledge of them. It has not been asked and does not expect that it will be in a position to provide relevant evidence to the inquiry on those matters. This is in contrast to the issues which are engaged by phase 2 of the inquiry, where the department clearly has a direct involvement in, for example, the matters raised under the heading of issue 10 in the list of issues. But the absence of direct involvement in phase 1 does not mean a lack of attention to and concern about the evidence that you may hear in phase 1. Far from it. Although the focus of phase 1 is not about the extent of industry's compliance with the regulatory regime. As is clear from some of the expert reports that the inquiry has commissioned, numerous, extensive and interrelated compliance issues with regard to the construction and refurbishment of the building will emerge in phase one, along perhaps with issues as to the efficiency and effectiveness of the regulatory regime itself in securing public safety. And as will have been apparent to you and your team, the department has not and is not waiting for the conclusions of this inquiry before taking robust action where that is necessary in order to secure the safety of the public or where improvements can be made. So, although you have decided in your response document of December 2017 that phase one will not involve any examination of the reasons why things happened as they did or what should have happened, and that in phase one there will be no qualitative investigation into any arrangements, decisions, regulations or policies, as it has done in the past, the department will continue to address issues of urgent concern as a result of the process of the inquiry, including within phase one. That is why it is concerned with phase one and why we are working closely with the Home Office, who now have governmental responsibility for fire and rescue policy. The department recognises that the Grenfell Tower fire uncovered widespread failures in the fire safety regime for high-rise residential buildings. That is why it immediately worked with fire safety experts to issue advice to owners of affected buildings, taking steps to ensure that every high-rise building with unsafe cladding was identified and made safe as soon as possible, and committed to a full review of the building regulatory system to make sure that all of the lessons from the tragedy were fully realised and acted on. That is why it has shared the inquiry's expert reports, with your permission, with the department's independent expert panel to make sure that any further action that is needed can be taken immediately. And that is why the department has also committed in reverse to providing to the inquiry documents underlying the Hackett review. In short, sir, nothing is more important than keeping people safe. As the inquiry continues its work, we in the department will ensure that any urgent public safety issues that the inquiry uncovers are immediately dealt with and that the survivors are fully supported. Thank you, sir.
Thank you very much. And now, finally for today, Ms. Studd is going to make a statement on behalf of the Mayor of London. But take your time, that's perfectly right.
So the Mayor of London has pledged to make London a city for all Londoners. And as a result of that pledge, he has particular concern for the bereaved survivors and residents of the Grenfell fire. As Mr. Millett, Queen's Counsel, clearly acknowledged on Monday, and others, perhaps Mr. Friedman, Queen's Counsel, most graphically have echoed, the commemorations last week provided us with the privilege of knowing a little bit about those who died and the place that they held in the hearts of their loved ones. For the Mayor, who was represented throughout, but who attended in person last Wednesday, it provided a very clear illustration, if one were needed, of the importance this inquiry and its need to explore relentlessly in this phase the cause and spread of this fire. This inquiry must reflect a moment in history when we can say this will not and cannot happen again in our great capital city. as Mr. Thomas, Queen's Counsel, said earlier, let this be the beginning of the end. The testaments of the bereaved survivors and relatives are also a stark reminder of the duty on each and every one of us with a role in this inquiry, in whatever capacity, to work rapidly, tirelessly, and with transparency to ensure that we learn every lesson we can, even the difficult ones, to prevent any reoccurrence of the devastating events of the 14th of June 2017. This duty clearly and obviously must extend to those responsible for the redesign and renovation of Grenfell Tower and those corporate core participants that have been paid by the taxpayer for their work. The Mayor welcomes the Prime Minister's recent decision to appoint additional panel members to sit with you, sir, in Phase 2. He considers the appointment of panel members will bring, as they must, both diversity and different life experience to this inquiry, and can only assist in making a vital contribution to ensuring greater public confidence in the process as a whole. He would endorse Mr. Mansfield of Queen's Counsel's call for their early appointment and their involvement in the hearings of Phase 1. Adding his voice to others, the Mayor has written to you asking you to renew your efforts in relation to finding and securing a more suitable venue than this venue. It is obviously unsatisfactory that less than 20% of the bereaved survivors and resident core participants can be present and actively participate in the main room of the inquiry at any one time. And even then, there are issues of space and comfort and the lack of ability for them to take notes and give instructions to their lawyers. We are sure that extensive inquiries have been made and that they will continue to be made. We understand that it is not easy to find suitable accommodation for an inquiry of this size. However, it is clearly eroding the number of core participants who are attending the inquiry, and at the very least, in the interests of transparency and in order to promote confidence in the process, we would ask you to let the core participants know what efforts have been made to date to find alternative accommodation for this inquiry, to give them the confidence that the inquiry has this issue very much in focus as the hearings continue. In addition to the proper focus on the bereaved survivors and residents of the Grenfell Tower and the need to learn lessons, even uncomfortable ones, in relation to the decisions made in the course of a very fast-moving emergency response, the Mayor would also wish the inquiry to highlight the actions of individual firefighters, search and rescue team members, and police officers who showed breathtaking bravery going forward into danger. These individuals, and there were many, showed the world what public service really means, risking their own lives in order to save the lives of others. These people will be heard in this phase of the inquiry, and their conduct should be recognised for the remarkable demonstration of the human spirit acting in the service of others. The Mayor would also like the inquiry to recognise and acknowledge in this phase the extraordinary coming together of the local community in the course of and in the immediate aftermath of devastating tragedy. This is a community which filled the vacuum left by the local authority, rallied, sought to, and did provide support to those directly affected in every way that it could in the days and weeks that followed the 14th of June, and, as illustrated last week, at the commemorative hearings. It continues to do so. Given the obvious and admitted failures of the local authority to provide welfare and support to the bereaved survivors and relatives of Grenfell Tower, the Mayor would invite you to consider whether the incumbent of his office should have a more specific or perhaps even a statutory role to provide or authorise mutual aid in the aftermath of such a major incident. Until now, the evidence which will be heard by the inquiry over the next few weeks and months has not been widely disseminated and has been confidential to the inquiry and core participants until these hearings commence. The Mayor is very conscious that the content of the evidence to be heard in this phase of the oral hearings will inevitably bring with it further concern to those who reside in high-rise buildings and in accommodation similar to Grenfell Tower. The inquiry will be aware that those with responsibility for housing took some action in the immediate aftermath of the fire to reduce public concern and to increase the safety of those residing in tower blocks. Those actions were and have been more recently widely reported in the press. That has not prevented residents of high-rise buildings continuing to experience wholly understandable fears, concerns and worries about their ability to be safe and their ability to keep their families safe in their own homes. The Mayor considers that there is much further work to do and that you, sir, and your inquiry play a vital role in this. Mr Weatherby, Queen's Counsel, asked yesterday whether any other of the core participants would support an outright ban on the use of combustible cladding on high-rise buildings. The Mayor has already made a clear and unambiguous public comment in response to the Hackett Review, confirming his support for its immediate ban. This is just the type of urgent safety consideration that this inquiry must consider in the course of the Phase 1 hearings. As the Mayor has previously indicated, there is a need to swiftly share and action any learning arising from the oral hearings of Phase 1 and not merely at its conclusion. The Mayor wishes the inquiry and the public to know that he is committed to assisting the inquiry to disseminate and implement any measures which it is considered require immediate attention, insofar as he has the power to do so, and expects that other relevant bodies or local authorities will do the same. For local authorities, registered social landlords and private landlords, this will have to be a matter of priority. And we make it plain that on behalf of the affected residents of London, the Mayor will use whatever methods available to him to ensure that these issues are prioritised. While the Mayor acknowledges the painstaking investigation being undertaken by the Metropolitan Police, he also wishes to highlight and emphasise the need for accountability. It is imperative that either in the course of these hearings or elsewhere, those bearing culpable responsibility for the circumstances that allowed this tragedy to occur are held to account, and that through the inquiry's work, we can ensure that nothing like the awful events at Grenfell Tower can ever occur in our country again.
Thank you very much. Well, that's a convenient point to break for today. We'll resume tomorrow with further statements at 10 o'clock. Can I just mention one thing before I rise? It may be that some of you are intending to stay in the building to talk about the day's events or other matters after I rise. I doubt that many of you will be here still at 5:30, but if you are, you ought to be aware that there will be a fire alarm test at 5:30. No, it's been put back. Yeah. Yeah, the confusion at this end is that we were originally told to expect it at 4:45, but I received a message just before I came back in that it had been put back to 5:30. So that's why I've told you 5:30.